Tommy V in Michigan. He was on fire this morning.
Okay, thank you, Tommy V in Michigan. Yes, sir. If you share my prayers.
Tommy V's on. Yeah, we'll jump over there.
Tommy V doing great stuff over there.
Sir, can you tell me your name?
Gene Kerney.
All right, thank you, Mr. Kerney. All right, this is State of Michigan versus Gene Kerney. Case 2. All right, Mr. Kerney, after I call the case, I'm going to put you on mute because there's a lot of feedback, but no worries. State of Michigan versus Gene Kerney, case 24057-58701. Today is the date set for a bond redetermination hearing. Can I have appearances, please?
Samuel A. Ragan for the people, Your Honor.
Right on behalf of Mr. Kerney, Your Honor.
All right, Mr. Kerney, could you state your name for the record?
Yes, sir. Gene Kerney.
All right, thank you, Mr. Kerney. Today is the date set for the redetermination. Bond is intentionally unaffordable. Mr. Reagan asked to bond.
That's the bond. Mr. Kerney, judge, is 25 years of age. Lifelong resident of this area, judge. He does live in the Detroit area, so he has strong ties, does have children. So he not a flight risk, judge, whatsoever. What I'm asking the court, the bond is $75,000 cash. Judge, this is an unfortunate situation with a lot of folks, Judge. But I think what happened was there was some words exchanged by Mr. Kerney and another individual, and then Mr. Kerney ends up getting jumped by 4 individuals, and he ends up getting assaulted, and he ends up getting beat up. But everybody else is able to give statements against him because they're all together. So it makes it look like he was the aggressor, but Judge, when we had a conversation about it and talked about what really happened, he was able to give us some insight on really what happened. He was knocked unconscious. Mr. Kerney was knocked unconscious, Your Honor. He doesn't have any pending cases. He works at Chrysler every day, Judge, Monday through Friday, 6 a.m. to 2 p.m., has a good job. Again, it's not a flight risk. I'm asking the court, Judge, to consider personal bond for him so he can get back to work, Your Honor. Again, once this case matriculates, I'm sure that more information will come out and we will find out. Mr. Kerney will get a chance to tell his side of the story and not just listen to the hearsay document that Mr. Ragnar will get ready to read to you. But we want his side to be heard as well, Judge. And this is not the time, obviously, but we're asking the court to consider a personal bond at this time.
All right, Mr. Ragnar.
Well, Your Honor, it's interesting that we're asking that the bond remain in place. It's a very assaultive matter. The defendant is assaulting victim number 1, who is pregnant. As he's assaulting her, he then grabs her phone, smashes it on the ground. Victim number 2, who is there to assist the victim number 1 when she's going to get her car towed because it was disabled, tries to intervene. He then punches her in the face, Your Honor. And interesting enough, Your Honor, all this is on video, him punching them in the face, smashing the phone. So then you have 2 men who try to intervene and to help out. He starts fighting with them, and he is knocked out. He's knocked unconscious and on the ground, but when he gets up, he runs in the house and comes back out with a knife and tries to stab both of the men who are standing by his vehicles at the time. And they were able to stop that. He continues to try to do it. So it's not like he could have walked away in the very beginning and not had any of this go on, but he chose to fight, to assault the pregnant woman to assault victim number 2 and to try to stab the 2 men that intervened to help the 2 ladies who were being assaulted. And he continues to try to stab them. Even when he failed, he comes back and tries to do it again. Your Honor, he is on probation. He pled guilty to CCW on 2/23/24. So for a man being on probation at this time, Your Honor, plus he has this case, I believe, depicts an assaultive matter against 4 people, 4 different people. So he can argue all the rest of his defense in court. That's not why we're here today. We believe he is definitely a assaultive behavior is a danger to the victim, all 4 victims, and to anyone else he comes in contact, apparently. So we're asking that the bond remain in place. Thank you.
Oh, okay, Mr. Kerney, I see that you're moving your mouth like you wanted to say something. You're on mute right now, so I can't hear you, but that's okay. I'm going to put you in the room with your attorney. Let him know what you want to say. If it's something that adds to his argument, I'm pretty sure he's going to let me know. So I'm going to put you in the breakout room right now.
A few moments later.
All right, back in the record on Mr. Kerney. Mr. Reagan, is there anything else that you want the court to know at this time?
Yeah, I think one of the things we wanted to correct, Judge, Mr. Kerney is not on probation right now for CCW. I think that's important to state, because I think it was stated that he's on a probation right now, and he's not. But he just reiterating the things I said. He's 5'6", 120. The persons that jumped out on him was 6'7". They came out the cars, pulled up with knives. He didn't have that. That wasn't what happened. He got to an argument. He called for people to come help his child's mother. Never tried to assault her. They did get into an argument. That is correct. All he knew was 3 cars that pulled up, and they came out with knives and jumped him. And he showed me some of the marks on him. And that's what we had talked about earlier. But I think he just wanted to reiterate that stuff to me and let it be known about the probation. I think that was important too.
Well, Your Honor, I believe he did plead guilty on the state. I'm not sure if he's been sentenced yet or not.
No. He successfully completed it in the past. He had successfully completed it.
You guys are both telling me stuff that I already know.
I was going to say,
Mr. Robbins completed his probation. It was pled before Judge Robbins at 36th District Court. Yeah. But I already know this. All right. As to Mr. Kerney, sir, I am going to reduce the bond to $75,000 personal with that GPS tether for monitoring purposes. You're to have no contact with all 4 complaining witnesses in this matter. Sir, it looks like the place of the offense was your address. So I am suggesting that you have no reason whatsoever to have contact with anybody else associated with this case until it plays out. Sir, a violation of that no contact order is going to result in this matter being remanded. So you'll be in custody until the case is concluded. Do you understand? Okay. You're mouthing yes. I know that you're on. I think I still got you on mute. 1 second. Okay.
Yeah. Yes. Could you say that? You said I'm going. Can you say that again?
I gave you a personal bond with no tether, no contact with the complaining witnesses in this case. You got no reason to have contact with them.
I believe you said tether, Your Honor. Monitoring is, I believe.
Yeah, I said with the tether.
Oh, thank you.
No contact with the complaining witnesses, and the tether is for monitoring purposes. All right, sir, your next date. Yes, sir.
So will I be released today?
After your tether is on. I don't know when that's going to happen, but as soon as you get the tether, you're going to be able to be released.
Okay.
1 second, sir. All right, Mr. Kerney, your next date is June 12th, 2024 before Judge King. June 12th.
Okay.
All right, that concludes the hearing.
Thank you, Your Honor.
Thank you, Judge.
Hey, don't you?
Mr. Wilson, can you hear me?
Yes, sir.
All right, this is the state of Michigan versus Tyler Wilson, case 24057555101. Also case 24044834001 and case 23044869001. Today is the date set for redetermination hearings as to all matters. Appearances, please.
Family Reagan for the people, Your Honor.
Deliberate on behalf of Mr. Wilson, Your Honor, to all matters.
All right, Mr. Watt, strike that. Mr. Wilson, could you state your name for the record?
Yes, sir. My name is Tyler Wilson.
All right, thank you, Mr. Wilson. Bond is set intentionally unaffordable in this matter. Mr. Reagan, I guess I have three cases. Let's start with, well, I'll let you make a general argument and then I'll decide on each of the cases. You can go ahead.
Thank you, Judge. He's 25, no prior. Only thing he has these three matters pending, Judge, 23 case and then 224 cases, Judge. He works at Ford Motor, does have children, lives in the Metro Detroit area, lives in Detroit, Judge. So he has ties to the community. He's not a flight risk. He works every day, Your Honor. You know, I'm asking the court respectfully to grant, you know, I think 50,000 cash is excessive. One of the cases is a MDP that he has a $50,000 cash bond on a malicious destruction of property on a Ford Explorer. You know, I just think they're excessive. I think no contact could suffice here, Judge, for purposes of bond. Again, we're not trying cases in terms of guilt or innocence. We're just looking at bond. So I think a personal bond, 50,000 personal on each. The court wanted to impose a tether, you know, for monitoring purposes. Like I said, he works every day. You know, works two jobs. So, you know, Judge, I think, you know, he's working, making a living, won't have contact with this young lady, Judge. He actually is expecting a child with a new relationship. This complaint is a child's mother, but they're not in a relationship. He has a new relationship. They don't live together. He's moved on with his life, Judge. So I'm asking the court to grant personal bond with the condition of no contact.
All right, Mr. Ragnar.
Yeah, the people are asking for the $500 cash surety bond to remain in place. They're asking for the other misdemeanor charge of $50,000 cash to remain in place. And we're asking that the felonious assault bond be increased to $250,000 cash. All three cases involve the same complainant, the same woman, Your Honor. Okay. The case back from 6/27/23, where he was, upon arrival, the police found him on the side of the house. Defendant came home. The complainant came home to her mother's house. She saw that things were disarrayed. She looked through the house to see if anyone's there. She saw the defendant hiding in his mother's closet. So with that, she just walked outside like nothing had happened and called the police, who subsequently came out and arrested him, Your Honor. The second case, Your Honor, which happened in 5/25/24, is that the defendant and her got into an argument and said that he was going to, he accused her of being with another male, I guess. And then after about 30 minutes, after he left, he came back and forth and said that he threatened to do damage to her vehicle so she could not drive it. He went around her vehicle. She sees him outside of a window doing that, comes outside, and the vehicle's damaged, a license plate's bent, and a windshield wiper is broken. But the situation on 5/26/24 is extremely serious, Your Honor. The complainant, the same woman, and her male friend, victim number 2, were stopped at a traffic light when the defendant comes up in a Jeep automobile driven by someone else. At the light, he gets out of the car. The victim number 2 sees him get out of the car, reach under her seat, and grab a gun. She said, "That looks like Tyler Wilson." And the victim number 1, Miss Walton, says, "That is him." With that, he points the gun. They take off driving the vehicle, okay? Now, he shoots at the vehicle a number of times. One of the shots goes through the back hatch of the vehicle, okay? And goes through by the passenger side through the car. So there's a hole in the car. But in the back seat where that bullet went through there was an infant child in a car seat, which could have been killed. So we got him shooting at her in the middle of a street and following them, shooting at them. So very serious, very dangerous. I think a $250,000 cash bond is appropriate in this situation. I think he's a great danger to this woman for over a year with 3 separate incidents against her, assaultive behavior. Well, one with damage to a property. So we're asking for that bond to be increased to $250,000. Thank you.
Okay, give me a minute. All right, I've had a chance to review the allegations set forth. Let me ask you this, Mr. Ragnan or Mr. Reagan, if you know, is the defendant on probation, parole, or awaiting sentence on any other cases?
I don't believe so, Judge, no.
I don't believe so, Your Honor.
All right, as to case 230448691, this is the breaking and entering charge before Judge Garrett. I am going to amend the bond to $500 personal, no contact with the complaining witness. As to case 2404434, matter is charged malicious destruction of property. I'm going to amend this to a $50,000 personal bond. It's currently set before Judge Bryant, but these matters should both be set before Judge Garrett, and we're going to make sure we get the same date. As to both cases, as to the felony matter, case 24057555101, bond is currently set at $50,000 cash. That bond is going to remain. Here I have a situation where after a prolonged set of contact, at least according to the allegations, and they are allegations at this point, someone's car was shot at, identified by the 2 witnesses as the defendant. I would note that someone not related to this case, an officer, observed a bullet hole in that car, and the car is stopped in the area that those shots allegedly took place. I think there is there's clear and convincing evidence that there is an inherent danger to the people associated with this case, the complaining witnesses, and bond is going to remain the same on that matter.
Judge, can I talk to Mr. Wilson briefly? He had his hand up for a minute. He didn't go in.
Of course. So before we conclude the hearing, Mr. Wilson, I'm going to put you in the room with your attorney. You guys can have a private conversation, and then if Mr. Reagan has some more information, he'll put it on the record, okay?
Well, Judge, what? Well, okay.
A few moments later.
Mr. Reagan?
Yes, Judge. No, Judge, it was,
Here, I'm sorry, 1 second. Go ahead, Mr. Reagan.
we were talking about information, Judge, just from the malicious destruction case. He was saying that he actually owned that vehicle, Judge. That was related to the MDP, but he got a personal bond on that, so he knows that, Judge. My whole thing, what I was going to say prior to us going in, Judge, I understand the court's position. I understand the court's ruling, Your Honor, and what the court read. It just bothers me that, you know, the Wayne County prosecutor understands that, you know, they're not going to be able to prove reckless discharge of a firearm, anything like that, AWIM. So they don't charge that because they say that they thought they saw a bullet hole. They thought they saw this. They didn't say it was for sure, but you know, they charge FA and it's a 4-year felony, Judge. But that's what he's charged with. You're not charged with necessarily shooting into a car, but that's what's in the investigator's report. So I understand the court's position and what the court has to go by. So I do understand that, Judge, but it just upsets me that that's the process in which we have to deal with, because he's not charged with shooting at a car, basically. They're just saying he did.
Yeah, Mr. Reagan, I don't know why it's not charged that way, because what I do have is, at least according to the allegations, witnesses indicating they hear 2 shots.
No, they said they heard what they thought were 2 shots. Not that they heard what they thought.
Okay, so what they wrote was they thought was 2 shots.
Mm-hmm.
I have a car that was pulled over in the same area of this alleged offense.
Right.
And then I have what an independent person believed to be a bullet hole in the back.
Believed to be.
This is exactly what believe. This is what they wrote.
Right.
There's going to be testimony on this that is going to be heard that has nothing to do with me or has nothing to do with you. And then that's going to decide one way or the other. We're just here to schedule bond based on what I have in front of me.
Right. Oh no, that's why I said I understand the court's position. Yeah. I do.
So Mr. Wilson's going to get his day in court. But this bond is set, you know, based on the allegations, based on what I have in front of me to establish, whether the community can be protected at this time without further information. And I don't believe it can without a cash bond. So that's why I set the bond that I did. Mr. Wilson, you're going to have 2 different dates. Actually, 3 different dates, because the felony matter has a probable cause conference and then an exam that's scheduled. So I'm going to give you the probable cause conference for the felony matter. That's going to be one second. June 12th, before Judge King. We scheduled both of the misdemeanor matters before Judge Austin Garrett on June 25th, and that's before Judge Austin Garrett for both of those cases. All right, and that concludes this hearing.
Thank you, Your Honor.